This afternoon, a development. Trump's lawyers faced off in a federal courtroom against the Justice Department for the first time since that search. The question before Judge Eileen Kennan, whether or not to appoint a special master to review the documents taken during the FBI search. Donald Trump's lawyers argued that a special master would help identify if any of the evidence seized on August 8th contains potential attorney-client or executive privilege issues. Meanwhile, Jay Bratt, he's a top counterintelligence official at DOJ, argued that some of the Trump team's requests were premature, and that the bottom line is that Trump had a stash of documents that don't belong to him. Judge Kennan did not announce a decision on the special master request, saying she would issue a written ruling at a later date, but she did say that she would make public a more detailed list of the items the FBI took during its search on August 8th, meaning we will likely get a much better understanding of what classified information and documents the twice-impeached ex-president has been hoarding at his residence. It's where we begin the hour with some of our favorite reporters and friends. Asha Rangappa is here, former FBI special agent for counterintelligence, now a senior lecturer and assistant dean at Yale Jackson School of Global Affairs. A.B. Stoddard is still with us, associate editor and columnist for Real Clear Politics. Asha, take me through the significance of this today. And I shared some New York Times reporting in the last hour that at the end of the day, nothing is on the table to thwart the investigation. It's really a potential delay that's on the table today.
That's what it sounds like, though, honestly, given that some of these claims are so novel and quite strange, they kind of upend some well-held legal principles. It's really unclear where it would go if this judge starts to open the door towards it. So for example, I'll go with just sort of the government's argument because it's actually logical. The government argued that Trump doesn't have any possessory interest in these documents, that he's not actually the legal custodian. He's basically, the thief who's taken them, that he also doesn't have any executive privilege, and that he's also delayed in filing this request. If she were to open the door to a special master, she then essentially upend some of these ideas, right? She suggests that he does have a possessory interest in these documents, which then sets it up as, a competition between a former executive and a current executive in terms of the privilege. So I'm not really sure where this would go, and I'm hoping that it won't be more than a small delay if it is, but we just have to see what she says.
Asha, let me show you something Sue Gordon said about this question of classification and just this whole worldview that the ex-president's attorneys seem to be arguing from. And it's not just the possession that they belong to him, but it's around classification, that regardless of the ramifications for U.S. national security or that of our allies, he can wave a wand and do what he wants. And there's no evidence he did that anyway. Here's Sue.
The act of declassifying is not a personal act. It's not an act for preference. It's not an act because I want to. It's not because I want to do something. It's because it serves either the national or the public interest. And it's a process that you go through, that you work with experts to say, if I declassify this, what will the impact be and can we bear it? So it isn't something casually done, regardless of whether you have the authority to do so or not. And it isn't in order to protect yourself or to aggrandize yourself. It's an entirely different thing.
They don't understand. Something could be marked top secret, could be marked classified. The Presidential Records Act, he would have said this is declassified. It doesn't get a new marking all the time. He's left the office. It is a complete public spectacle.
A million things wrong with what the ex-president's lawyer, Alina Habba, said. But let's focus on what Sue Gordon says first. She says, regardless of whether you have the authority to do so or not, it isn't in order to protect yourself. You don't declassify things because now you're in trouble for criminally taking them, keeping them, hoarding them, and lying about giving them back.
Right. And I think Sue is exactly right. What she's getting at is these aren't just arbitrary labels that suddenly make something legal and not legal. The classification, the different tiers actually represent an assessment, a substantive assessment of the level of damage that this information can do to national security. it's frankly probably not possible for a single person, particularly the president, to actually make that assessment on his own. That's why in the declassification process, you bring in the agencies that have equities who really understand what the consequences and ramifications would be of disclosing this information. So really this claim that he declassified is basically saying, well, I made the judgment call that these don't damage national security, which is just not something that he is really in a position to do. So even though I guess legally as president he could do it, I think what Sue is saying, it wouldn't make any sense. The changing of those labels would not actually mean anything, substantively speaking.
And I think, AB, what Sue Gordon made clear here in this hour yesterday is that the declassification is a process that is collaborative. It's not a decision that is unitary because you got caught literally with your hand in the classified, most sensitive classified cookie jar. And there's no one arguing that it's anything other than that on the part of Donald Trump.
This is preposterous. And the confusion and the BS is the point. The court filings have not said his own lawyers have not said in these filings that he declassified anything, that anything the Department of Justice is talking about has been declassified. And as Sue Gordon lays out, there is a massive paper trail for this process. It doesn't happen in Donald Trump's head. But he likes to put this crap out on Truth Social to confuse his followers and make them believe there's a new talking point to survive the next news day and to give people on Fox News things to say in his defense. More process, more procedure, more jargon, more paperwork, more delays is the point. What's stunning to me, if you just take a look back, Nicole, is that none of us had to know any of this. The former president, revealed the search at Mar-a-Lago and then teed up the entire Republican Party to send out manic tweets on his behalf that night, attacking FBI agents, and then the days that followed. This is an unforced error, this request for a special master. Now, Asha is the legal mind, and she's probably right that this could get into very tricky areas, but it still managed to prompt a really embarrassing, fact-filled, damning document from the Department of Justice laying out why he is likely guilty of several federal crimes. So it was a self-own, but again, it was a way to just have another process that he could talk about and people could throw around on social media on his behalf to people they do not believe are smart enough to understand. Again, legally, I don't know where it's going, but it doesn't sound like it would do anything to really upset or delay significantly the investigation. This declassified BS is all intentional to confuse people on cable news and on Facebook. It's not even in the document. His lawyers aren't pretending that he declassified anything. There's no paperwork to show that it happened. It's beyond belief that he's still putting it up on his website, on his whatever it is, Truth Social today.
So, AB, there's some New York Times reporting exactly to the effect of what you're talking about. Times reporters write this. It's as if Trump, seeming not to fully grasp the potential hazards of his modest legal move, cracked open a door, allowing the Justice Department to push past him and seize the initiative. The Trump team got more than they bargained for, said Preet Bharara, former U.S. attorney in Manhattan and a longtime critic of Trump. In response to a thin and tardy special master motion, DOJ was given the opportunity to be expansive.
Precisely. None of us had to know about any of this. He didn't need to look so guilty. And what's so great about him and these lawyer women that go on TV for him is it's just a symbiotic relationship. They want the fame and they're willing to trash their entire legal career for his ridiculous requests that make him look more guilty. And everybody's happy because for him, it's all about a PR move. And for them, they think that working with him and letting him incriminate himself and admit to potential crimes on Truth Social day in and day out when they're making these filings and working into the night to write them up. It's obviously fine with them, no matter how much he derails their own work. So this is all, again, a performance. And Donald Trump is a showman. And it's all about keeping himself in the news, raising money off of it, and just keep blowing a lot of BS to his voters.
With extraordinary potential new risk being faced now by FBI agents and DOJ attorneys, my colleague, NBC News correspondent Vaughn Hilliard, is outside the courthouse where all of this went down today in West Palm Beach, Florida. Vaughn, what is the latest?
I mean, this is a situation which you and AB were just outlining here, in which it's not clear the extent to which Trump's lawyers even understand what documents the Department of Justice has. And that is why it was significant that the judge indicated here at this hearing that she is looking to unseal a more detailed list of the documents that were seized on August 8th and are now in the hands of investigators. That came at the request of the Trump team here, and it will be made public. But it's interesting to note that it was the Trump team that wants this to be made public, because they are seeking to have a better understanding of what one could say they're trying to defend the former president against here, because it was a Trump lawyer and a custodian of his records who on June 3rd signed a sworn affidavit that all relevant documents had been turned over to the Department of Justice. It's not clear whether that signature was signed on the dotted lines with the understanding that truly all the documents under their belief had actually been turned over or not. But what we now know from this filing here is that more than double the number of classified materials had been seized by the FBI compared to the number of records willingly turned over by Trump and his team on June 3rd here. We do not have a determination here from the judge about whether a special master will be appointed here or not. The Trump team is trying to make the case, and it's important to note they do have a new lawyer that is working on their team, a former Florida Solicitor General who has deep ties to the Republican Party, worked on the transition team to Ron DeSantis here. They are trying to make the case that, it was Nixon v. USA is limited case law, is what they are contesting. It was obviously the unanimous decision of the Supreme Court that then President Nixon had to turn over not only tapes, but material because a criminal investigation did not grant immunity from a current sitting president from turning over documents that could potentially help a criminal investigation. Yet, that is where you see the defenders of the former president, including himself, make the case this is limited. If I could, Nicole, one other point. You guys were talking about these lawyers. It was Alina Habba, who is not actually working on this specific case, but she's a Trump attorney who is going on national airwaves to talk about this case. She actually is representing him in the Trump organization with the New York Attorney General's office. But last night, she made what you could say maybe inadvertent admission in which she said that she had frequently been inside of Trump's office before, but also said there's other guests that are frequently there, which would suggest that there are individuals who had been in the premises of these very documents the Department of Justice now has their hands on.
And Asha, it's clear that the FBI did two things. One, they tried to get back into the possession of the government these classified materials for many, many months. And two, there's a stream of evidence and information really coming in real time to the government. And it's clear from Trump's filings that he didn't know who they are, but they knew that what they got was incomplete. They knew that the material was in places other than the storage room. We know that from the filing. And they know that these things continue to be at risk and, as Vaughn just said, exposed.
Yes, and to the point that was just made in terms of these admissions that are being made by his lawyers and even Trump, that these documents were outside of the storage room after they had certified that they had been turned in, and they were in high traffic areas where they could have been compromised. I think Trump on Truth Social today said, he was upset with how the photograph that was submitted with the Department of Justice's court filings, that's now become famous. That's a standard documentation photo taken during a search. But he said, well, that's not how they were. They were in cartons. So he's basically acknowledging that he knew that they were stored in his office after they had told the Department of Justice that they had given them everything. I mean, he's basically confessing to obstruction of justice. And I think, Nicole, the only explanation I can come up with is that they may be convinced, and this is part of what they've tried to argue, that Trump is entitled to have these documents, that there's no way the FBI or Department of Justice can actually enforce the ownership and custody part of the Presidential Records Act. And to get back to the special master, it's not clear what the remedy is. If they identify, if she goes down this road of identifying documents that are executive privilege, under the law, as I read it, that means that they would go back to the National Archives, if any, at the very least. Maybe the lawyers think they're going to go back to him. They seem to be behaving that way, at least in terms of the statements that they're making, because they are not helping their own case when it comes to the potential criminal charges against them.
When you talk about sort of the chain of command of these documents and what the government knows, do you think there's an active investigation into whether they've been copied or squirreled away, or an inventory against which they're checking what they have been able to locate?
Well, in terms of the documents that they were looking for, there was quite a detailed list of the markings that they were searching for when they executed the search warrant. So they clearly they knew they were missing certain things, and they knew exactly the particular documents they were looking for. I think one of the challenges here is I'm not sure that they would be able to know if things have been duplicated. I mean, again, if these were in an office that was unsecure, with people coming through who could photograph them, I mean, that's not something that a forensic review of the actual document would be able to reveal. And so, I think this is going to be a part of the damage assessment, is really saying, are we going to just assume that all of these secrets are out there somewhere, somebody is holding them? And what does that mean in terms of our methods, our sources, our collection, and, our intelligence capabilities and how we're operating on them?
Vaughn, was there anything on the president's attorneys that acknowledged or depicted the twice impeached ex-president as cognizant of the national security importance and specialness of classified material?
Well, they made the comparison to this being an overdue library book.
Right.
And those are the lawyers for Donald Trump. And Donald Trump is not one to have shown any regret up to this point. He even suggested that evidence may have been planted at Mar-a-Lago here. But no, his attorneys did not make that case. But I think it's important to note that the Office of the Director of National Intelligence is currently reviewing these very documents with the FBI, with the Department of Justice, to determine the extent to which there were potential national security threats. If, in fact, these documents had been either obtained, taken, photographed, somehow the contents of them had made their way outside of Mar-a-Lago, quite frankly, here. And that is where you saw the Department of Justice lawyers making the case that time was of the essence here, and that to delay this any longer could potentially, put not only our sources, but our methods of the U.S. national intelligence community at risk. And that is why they were making the case here. And I think that it's important to note we don't know exactly what those documents pertained or were included. And I think that is why you heard those lawyers make the case that review needs to continue so they have an understanding of what is in these documents themselves.
It is still, if you step back, just remarkable that an ex-president of the United States of America doesn't want a review of whether he wittingly or unwittingly exposed state secrets. What a damage assessment done. Vaughn Hilliard, Asha Rangappa, and A.B. Stoddard, stay near. If anything breaks, we will